Today is look at the role of courts in a democracy and the role of courts in a new democracy, specifically South Africa. So the first thing I'm going to do is set the scene. We're going to talk a little bit about who does what in a constitutional democracy. We'll start off by defining a couple of the terms, like I guess you guys all know what a democracy is, but do you know what a constitutional democracy is, and what makes that different from just a general meaning of a democracy? Then we're going to have a look, as I said, at South Africa's constitutional history. This will necessarily be potted. I'm only going to start in 1948, and clearly it's got a history that goes way back before then. But I'm looking at the events that shaped this new document, this new constitution that they brought into effect in the early 90s, which will be the focus of the cases that you read last night. We're going to stop and have a look at one of the problems that comes up with the role of courts. It's kind of like walking the tightrope. It's this gentle balance between what courts do when they review public power and decisions of the executive. So the two cases that you saw were involving decisions of the legislature and the executive, and the court decided to play a role in somehow engaging with those decisions. So what we're going to be asking today is this appropriate in a constitutional democracy? What are the benefits of the courts doing this? What are the problems with the courts doing this? We're then going to finish off with the case studies. So Flori, I'll spend the most time on, which is the same-sex marriage case. And then we'll touch on TAC. But I don't want to steal Steph's thunder tomorrow, so we'll just go into some of the legal issues around that, but I'll let Steph go more into the social and political history that was the foundations for this case. So what is a democracy? Well, it's a system of government where the whole population, or all of the eligible members of a state, typically through elected representatives, and then a control of an organisation grouped by the majority of its members. So I've got some words in bold there. Eligible members. Does anyone know a little bit about South Africa's history and who was eligible members to vote and who was not eligible members to vote? So what we had was, before 96, we had a system in place called apartheid, and we'll look into apartheid a little bit further a few slides down, but it was a racialized system of governance whereby the majority of the South African population weren't allowed to vote. But they still called this a democracy, but it really wasn't. How can you have a democracy if most people in your country aren't voting for the officials in power and aren't having a say? But whole populations, do we let everybody vote? We have rules about voting. So we do not let minors vote. We don't let people who are, in this country, very controversially, we don't let prisoners vote, which is something that has been a point of contention. So eligible members of who votes, it's not everybody. It is a particular franchised group in a society who is allowed to vote. And that's often determined by the politics in the country that you're engaged in. Now, the second point that I want to ask is, well, so we're pretty well understanding what a democracy is. But what's a constitutional democracy? It's a system of government based on popular sovereignty in which the structures, powers, and limits of government are set forth in a constitution. What is the role of a constitution? Is it just like some document that sort of sits up there and gives some ideas about how we should govern? So we have legislation that can be brought through by the legislature. It can be repealed by the legislature who comes into power after government is formed by popular vote. But the Constitution is something a little bit more foundational. It's very hard to change constitutions. In my country, at least, we have to have a referendum to change a constitution. In the sort of 100+ year history, they've had, I think, 37 constitutional referendums, and only 7 have ever passed. And those have been about like really sort of obvious stuff. So we say that constitutions have a special role and a special status as law, as a kind of higher part of law. And so in a democracy, it is the Constitution also controls the powers that are exercised by each of the arms of government. So the next point that we want to talk about is each of the arms of government. Has anyone heard of this idea, the separation of powers? So separation of powers is the vesting of legislative, executive and judicial power in government in separate bodies. The final thing is rule of law. Here we are with our separation of powers, and this is something very important that we're going to be talking about for the next few minutes. So we've got our judiciary, power to make judgments on law, the parliament, the power to make law and change law, and the executive. So they put law into action. In some other countries, we have slightly different roles for the executive. So in Australia, the executive can't really veto what legislation is, but it is the driver of legislation. So the executive branch there is the government in cabinet, and it will determine policy, and so it'll be the driver of what becomes law in a way. It'll determine which bills are put before Parliament, and because it controls Parliament, it has more power in bringing through legislation in that way. If you wanted to destroy a judiciary, if you were some like evil dictator, but wannabe evil dictator, because you hadn't quite got rid of the judiciary yet, and they were still checking what you did, and you really didn't like it, how would you try and destroy it? We can bribe them, we can pay them, you have your own guy there, but money talks, and so we can bribe them, and we can say, well, we're only going to give you 2 years in this cushy job, and if you don't do what we say, that we're going to then, not renew your contract. So what things do we have in place to prevent this happening? Why would my plan fail in a constitutional democracy? Tenure. We usually have the judiciary has tenure, so they get appointed. They're not employed, they're appointed, and they do get paid, and it's out of the public purse, but that is set independently of the executive. They usually have independent pay commissions. So in all these ways, we're trying to keep our judiciary independent so that it can be a good body of review. But what happens if the judiciary gets too powerful? And particularly, what happens if the judiciary gets too powerful when we're in a new democracy, a fragile state that's just transitioned out of conflict, that has had its first democratic elections and is now trying to forge its way forward through popular elections, the will of the people. The point about constitutions, and we'll also look at this later on, is that it's words on a page. It's words on a page, and it's open to many different interpretations. And the judiciary can be powerful in putting an interpretation on what these words say. However, the government is the one that has been elected by the people. It's subject not to tenure. The legislature and the executive, they're not tenured. They can be voted out. If the people don't like what they're doing, they can get rid of them. But if we don't like what the judiciary is doing, we've got to take some pretty extreme measures to get them out of there. And so one of the problems I want you to think about today is this, and this is the tension that exists, especially in new democracies, is if the judiciary is micromanaging the role of the executive and the role of the legislature. If it's encroaching into their turf, then what does that do for the confidence that the people will have in these other arms of government? What impact will it have for this arm of government to respect judicial decisions when they come down? So that's another thing, is that the court can say what it wants, but if you ignore what the court says, which often happens, it happens more than you think. So it's this fragile balance of each institution according appropriate deference to the other, and respecting the roles, being vigorous in their own turf, but then also respecting the delicate balance and knowing what they're not responsible for, as well as knowing what they are responsible for. What is policy? So policy is a plan. It's the government's plan. It's something that they campaigned on. They're like, we're going to run the country this way. There are a million different ways that we could run the country, but our policy says we're going to do this. And we're going to enact legislation to allow us to reach this vision and this goal. So it's something very, very specific to the executive, and then needs the support of the legislature in passing laws in order to make it happen. So how do courts give judgments? And how does it come before a court? Someone has to come to a court with a matter, with a dispute. Courts don't just hear hypothetical problems. Courts have to hear an actual dispute between parties. They have to say, I want to do something, and this person won't let me. This person may be the executive, and they're acting under an executive power, or they're acting under a piece of legislation, and that's why I can't do it. Courts can't just pick their issues that come before them out of the sky. To a certain extent, the legislature and the executive can, but courts are very reactive institutions, so they can only give judgments on a matter that comes before them. Now, who's heard of this Latin phrase, stare decisis? Stare decisis. It's Latin. Lawyers love Latin. We love cases and we love Latin. Is otherwise known as precedent or case law. So it's what judges do when they make cases. That there's two sorts of law that they have resort to, and they resort to statutes that are made by the legislature, pieces of legislation, but they also look at case law and look at precedent, which is the way that other judges who came before them have decided the case. And this is why lawmaking is done by the legislature, but some people also say that lawmaking is done by the judiciary, because while judges don't necessarily make law on their own volition, when saying, well, we don't like how this is going, so we're going to say this. They have to wait for a case to come before them, but they can interpret what has been done in a particular way, and we call this the common law. It develops incrementally by each case coming before the courts, and the courts are required to look back on what has come before, but also to develop case law so that it's appropriate in the society in which they're sitting in at the particular time. So in that way, we could say maybe that judges do make law, but the extent to which they do is what we're going to be chatting about in our tightrope of what people do and what courts should do and what they shouldn't do. So we were talking before about the three arms of government, and they need to respect each other. We often say that's deference, and we usually talk about deference when we talk about the court, saying that they should defer to the executive, they should defer to the legislature, they should defer to them because on issues of public power, especially when policy is involved or polycentric decision making is involved, because the executive and the legislature have more resources. They have more of a mandate because they are elected by the people. So they've put their policy before the people at election, and the people have said, yeah, we like that. So they've got a mandate to carry out what they're doing. And so the courts will sometimes say, well, it's not our job to second guess them on what they're doing. All we're doing is making sure that they're adhering with the rules and the laws as set out in the Constitution. So, South Africa's constitutional transformation. We mentioned what apartheid was before. I was in South Africa earlier this year, and I was at the Constitutional Court, which is the highest court in South Africa, and they were doing a little school group tour, and someone asked the little school kids what was apartheid, and this little school kid put up their hand and said it was a time of sadness. And I thought that was really nice and really very cute. It was a time of sadness. It was a time of racial segregation in South Africa. We had huge human rights violations. South Africa was excluded from the 60s onwards from international community in many ways because of these violations. We had somebody called Nelson Mandela. What was he the leader of? The ANC, the African National Congress, which was banned by the apartheid government It was outlawed. Nelson Mandela went to prison for a very long time. But then there were uprisings, many people died, and we then get, in 1990, something happened. F.W. de Klerk was the head of state at the time. He realised that this was no longer a sustainable position for the government. There was so much killing, there was so much international pressure, there was so much impact upon the South African economy. And also, I would like to think that there was the moral imperative that what was happening in South Africa was wrong, that racial discrimination was wrong, that racial oppression, or oppression based on racialization, was wrong. And so talk started, and we started to see a transition in South Africa that was very different to transitions that happen in other countries. Some would argue that there wasn't a civil war. Some would say that there was, because there was a lot of conflict going on, but the whole state didn't deteriorate. They were able to negotiate a transition from the apartheid government to a democracy. And so this is why it was a very sort of interesting point in history. In 1990, Mandela was released after 27 years in prison. He went back and resumed his role. He's the leader of the African National Congress, and started multi-party talks with de Klerk. And then in 1993, they agreed on an interim constitution, which made provisions for the first democratic election to be held in South Africa. ANC, led by Mandela, won by a landslide, formed government. So in 1994, the first non-racialized election, Mandela became president, and this was also when the South African Constitutional Court was created. In 1996, they adopted a new constitution. So we had these things happen that were new. We had a new court. Here's a picture of the court. That's the symbol of the court, that little tree there. The reason why they had a tree, it was meant to be justice under the tree. It was referring to traditional African dispute resolution, and also that the constitution was meant to be the branches, and so that all disputes, people would come and resolve their disputes under the constitution. And so we had this new constitution, which was really, really remarkable. It was remarkable in a number of ways. The first was, it was remarkable because it empowered the Constitutional Court, sitting as the Supreme Court, to strike down laws that were in contravention with its terms. The second was that it entrusted the courts with developing a new set of principles, a new way forward in transition in South Africa. We talk about transformation a lot when we talk about South African law. And here is the preamble of this new constitution that sets these visions out. It involves human rights. It, for the first time, is one of the first instruments anywhere in the world to have socioeconomic rights and civil and political rights contained in the one document. So, we had all these bunch of rights all under this new constitution. But the court then, because it was deciding on such a broad area of decision making on healthcare, on housing, on medical services that were provided by the government, on education service, was able to review government decisions in these areas. We had a big question arise, well, what is the appropriate role of the court in this situation? It's there to try and buttress and stabilize these new principles that were set out in the preamble, a new idea of a South Africa that would no longer discriminate, where principles of equality would be embraced. But at the same time, it had to work with this newly created executive and newly created legislature in order to work out what its appropriate place was and its appropriate law was. So, were the judges, when applying provisions of the Constitution, just technicians who could mitigate the effect of unjust laws, but only on procedure and technical terms? So, as long as it was in the letter of the law and not the spirit of the law, does that mean an executive or an exercise of public power is okay? Or were they required to do something more? Something more might be to give effect to the principles that were set out in the new Constitution. So to breathe life into the Constitution, to ensure that they weren't just words on a page, that they were actually principles that were achievable, that there were remedies, that people could come to court. They could say that my rights are being violated and the court could actually do something about it. But always remembering that their role was not to second guess the executive and the legislature, but merely to ensure that there was consistency with the principles set out in the Constitution. So what I might do now is move on to Furi. So 2 women wanted to get married and they weren't allowed to. Well, why weren't they allowed to? There were 2 reasons. One, common law. We talked about that before with precedent and with case law. Previously, the case law had developed to define marriage in South Africa as a union of one man with one woman to the exclusion, while it lasts, of all others. There was another reason why they couldn't get married, the Marriage Act. So the Marriage Act set out what the vows were going to be. So this was how to get legal recognition of your union, and it says, do you, AB, call the President to witness that you take CD as your lawful wife or husband? So it didn't contemplate same-sex marriage. What was the problem, though, bringing that to in the new South Africa with the new constitution? Equality provision, and it was prohibited to discriminate on the basis of sexual orientation. There was also another section in the Constitution that was very important. The Albie Sachs, the lead judgment, focused on this a lot in his decision. Dignity, yeah, dignity. So they brought, this was actually 2 cases that were argued together. So Furi brought a case that was based on the common law definition, but then there was also the Lesbian and Gay Equality Project with a group of other people brought a case at the same time arguing that the Marriage Act was unconstitutional. This often happens in law, especially with constitutional cases, and things get bunched together so the court can deal with this as a whole picture. So you would have realised in the judgment, the Furi judgment, that Justice Sachs was talking about this quite a lot, about whether or not these cases should be heard together, and he said that they were. So there were 2 main questions that went before the court. The first one was this unconstitutional? And the second one was, if yes, what was the appropriate remedy for the court to order? Now, as interesting as the first point is, what I want to focus on in the time we have left is the second point. So what was the appropriate remedy for the court to order? Because this is where we saw a lot of division. We saw division at the first instance in the Court of Appeal. We saw then division in the Constitutional Court. So Justice O'Regan wrote a dissenting decision. So what did they find on the unconstitutional point? Was the common law and the Marriage Act a breach of the equality guarantee and the dignity guarantee in the Constitution? Yes, 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 so it clearly was. Justice Sachs's decision talked a lot about the court's role as a transformative institution and as redressing wrongs of the past. He focused a lot on the discrimination and the pain that had been caused to same-sex couples previously through exclusion in law. It wasn't that this, and what was interesting about this case as well is that the Marriage Act, it wasn't that it prohibited, there was no prohibition on same-sex marriage. It just wasn't contemplated. They were just left out. And so Justice Sachs talked a lot about the marginalisation and that it was not enough in a democracy for people just to be left alone behind closed doors to do what they pleased. But the dignity element in the Constitution required tolerance and required the embracing of all different types of relationships and all different types of people with all different types of lives. So that was something that was very important in this case, that it was saying that positive action needed to be taken in order to fulfill the equality guarantee and the dignity guarantee. But then when we got to, well, what was the court to do about it? So we had 2 things there. We had the common law and we had the legislation. So the common law is judge-made law. So what was the first option available to them? So basically the first one was that the courts could just say, well, the common law says that, a man and a woman, that's just outdated in a current democratic society. It needs to include same-sex marriage. The problem with that, it's controversial. It was the court making a decision that the legislature had not made. The legislature had put into effect other pieces of legislation that dealt with same-sex relationship rights. It had decriminalised sexual relations, same-sex sexual relations. It had chosen what it wanted to do, but it had not chosen to enforce same-sex marriage. So some people could say that if the court steps in, they're overriding the choice of the legislature. But another problem with only developing the common law was that it meant that there still was this Marriage Act. So there may be a right to under common law, but there's no way to do it. You can't be recognised unless you have vows that just take the vows that are set out in the Marriage Act. So that was the decision below, and that was what Justice Cameron below said that the court should do. That was very controversial because in no way could you say that Justice Cameron was an opponent of same-sex marriage. He is in fact a huge advocate of gay rights. But he was respecting what he saw was the appropriate role of the court in this situation. He said that they could deal with judge-made law, they could deal with updating precedent, but to go in there and read extra words into the piece of legislation, I mean, what is the court doing? They are not elected. There's been no discussion about it. They don't have all the resources. There might also be a number of options on what could happen and the ways that you could formulate the legislation. I mean, someone said before that one was to have man and man, woman and woman, another was to have spouse. There were a whole heap of options on how this law could be reformed. And the court said, well, one of the options before the court was to say, well, we can make a declaration saying this is unconstitutional, but we're not the legislature. We're not going to sit here and draft legislation. Another option was, and this is what the court did, and it was quite creative, was that they decided to bounce the question back. So they decided to say, well, you know, we've looked at this, and this law is bad. It's constitutionally bad. But we recognise our role. We recognise that we need to defer to you, that you are the best placed people to make this decision. You need to make a decision that's within the realm of the constitutional guarantee. But we're going to let you decide the form in which that decision is made. And so what they actually did was made an order saying that they needed to reform the law within 12 months, that they needed to legislate within 12 months to amend the Marriage Act in the way that they saw fit. But my question, and one of the questions that I've got for perhaps discussion group later, is what would happen if they didn't? What would happen if the court had said to the legislature, you know, go legislate or whatever? They held a big inquiry, they had huge amounts of debate, and then the legislature decided, no, not going to happen. Or what would happen, and these are hypothetical questions to think about at the moment, what would happen if the legislature did the opposite and said that it expressly prohibited same-sex marriage? Justice O'Regan, on the other hand, she dissented in this case, not on whether or not it was unconstitutional. Everyone was like, yeah, no-brainer. But she dissented on what the appropriate remedy was. And she noted that separation of powers was really, really important, but a litigant who brings a case to court is entitled to relief. You know, declaratory orders by the court just saying, well, it's unconstitutional, but sorry, you can't get married, sorry, you know, we're not going to do anything for you. She said that wasn't enough. And she said that the court actually was there to provide justice to the people that came before it. And so she would have said that she was actually going to read words in and say that this meant a man and man, a woman and woman, man and woman, so as to accord with the Constitution. But thank you very much. You've been really great. Sorry I took a bit longer than expected.